Good morning. This is Judge Alyssa Perez, presiding over the 210th District Court criminal docket for October 7th, 2021. All matters being heard today are being heard in accordance with all emergency orders and directives. Regarding COVID-19, in addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Panto, how would you call our first case, please?
Yes, Judge. Cause number 2021-0D00530. State of Texas versus Ivan Gabaldon. Announcement of counsel, please.
Brian Herrera for the state of Texas. Ready, Your Honor.
Omar Carmona and Denise Butterworth on behalf of Mr. Gabaldon. Ready, Your Honor.
Good morning. And so this is a continuation of our hearing on the defense motion to inspect physical evidence that was set a couple of days ago. Mr. Herrera, are you the one handling this case?
Yes, Your Honor.
Okay. And so I think we were going to get an update of on, I guess you were having some type of meeting. Can you give the court an update?
Yes, Judge. So I went over to the property office yesterday morning with someone from the homicide unit at our office. There are about 102 or so pieces of evidence. We whittled the list down to 22 items to be sent off for DNA testing. We are limited to only 10, but I'm requesting special permission from DPS to go over that limit just due to the urgency. Now, at this point, I'm waiting to hear back to see if they're going to take all 22. If not, there might be a few items that might be redundant. So if we need to limit it to 10, that's kind of up to DPS now. Now, I have started an email thread with Ms. Butterworth and Mr. Carmona so that we can get a evidence review on all the other items at the property office. Once we get a date, I can coordinate with PD and we can get that set up right away. And then lastly, Your Honor, for the items that were specifically listed in the motion, those have been requested. So we will get them in our office. I was told on the 14th, so that we can make copies and provide them to counsel. If we need to get them earlier, Your Honor, I can request that they be picked up directly from the property office so that we can help move that, expedite that even more. But I was told that they'll be in our office on the 14th and we'll make a copy available of all of those items. And then the items that we already do have been uploaded to Portal, and we will make copies of those and deliver those to counsel as well.
Okay, so let me understand, hold on, Ms. Butterworth, let me understand what you're saying, Mr. Herrera. With respect to the 22 items that you're identifying, are you representing to the court that you have made the request for those 22, that has been completed and you're waiting some type of agreement or confirmation from DPS?
Yes, Judge.
Okay, so it's only the request. It's not like 22 items have been sent out to be tested, right?
No, but once they tell me no, it's going to be the 10, then those 10 will be the ones that are sent off. But at this point, Your Honor, I mean, they're pretty strict on that policy, is my understanding. But if they're willing to accommodate us and accept the 22, we'll send those off immediately.
Okay. All right, let me ask this just because that was one of the items that was fresh in my mind. Ms. Butterworth, do you or Mr. Carmona, do you all have your client? I believe it was your client statement. Is that on
We do
Portal?
not.
Okay.
We do not, Judge.
Hold on. Does Mr. Herrera, does the state have that in your possession?
We do, Judge. It's being uploaded, and then we're making a copy of the disc so that can be handed off. So there'll be a copy on Portal and a disc that can be burned and provided to counsel.
Anything else, Mr. Herrera?
And then there's the the DVR, Your Honor, from the victims' cameras, and I believe those are the 3 discs. Now the other items, we can get those and provide copies as well. And that way we don't have to wait for them to be uploaded to portal. We can make copies and then hand deliver those to counsel. But we don't have those in our office as of right now. They're still over at the property office. I saw them yesterday.
Okay, Ms. Butterworth.
Thank you, Judge. Again, I just want to make a record of some of the things that are becoming glaringly clear. We met on Tuesday, October 5th, on this particular case in our desperate regard to have discovery turned over to the defense, basic discovery like our client statement. On today's date, Mr. Herrera is letting the court know that from the 5th to the 6th, there was an evidence review that was conducted by the state of Texas at the property office. And I just want to spell this out for the record. On the 5th, my client's statement had not been reviewed by the state of Texas, nor had any evidence. No evidence had been reviewed. And yet they do an evidence review the following day. I'm at a loss of words on how this could have been an educated evidence review when nobody's looked at the defendant's statement, nobody's looked at the file. I
And
just
Judge-
want to put that on the record.
Hold on, Mr. Herrera. Go ahead, Ms. Butterworth.
Mr. Herrera has been very gracious. He called me yesterday. I will tell you, I know that they are trying at this point to accommodate basically their tardiness in the game. And so he called and said that we're going to try to set up an evidence review. In this discussion, I let him know I can't have an educated evidence review on behalf of my client until we have discovery. And what I did was I suggested a better way to possibly turn over the discovery for everyone's benefit, including the state of Texas. When things are uploaded to the portal, especially the things that we're asking for, all of this electronic media, it gets uploaded to the portal with just a bunch of numbers, with no delineation of what it is that we're receiving, what it is that we're looking at. We then have to wait the 30 minutes to upload whatever the video evidence is on the portal that we don't know what it is because it's not being identified. And then we finally figure out, well, what it is that, and then we have to glean. For example, before this hearing, there was one video surveillance that was uploaded on portal. I have looked at this entire case. And the only reason, and then as I watched that video surveillance that is being identified, but nothing but a string of numbers, not telling me the business that it came from, not telling me the date of the surveillance, not telling me any of that other than a slew of numbers. I know the case because I have reviewed it. I was able to glean that maybe this is video surveillance from a nearby business of where the truck was ultimately dropped off. What I was telling Mr. Herrera is, number one, that is not fair to the defense that we have to do this on every single piece of evidence that's being turned over. And what I suggested is that we get copies of whatever they have where it's marked the same way it's marked for them. For example, at the property office, there should be a DVD that is marked. For example, in this case, there was some video surveillance that came from Ready Ice. At the property office, that DVD is going to be marked EPPD, our case number, video surveillance from the Ready Ice. That way, Mr. Carmona and I don't have to spend 2 hours when we upload something from or download something from the portal, figuring out, well, what is this? And more importantly, and I was sharing with Mr. Herrera just for their own benefit, it could could be that later on, when we're in the middle of this murder trial, that there is a question on whether this discovery was turned over or not. And a printed out list from the 3914 that's generated for the portal with a slew of numbers is never going to cut it when the state of Texas has to prove that they've turned over this particular discovery. And so I suggested, and what I need before I can set up an evidence review is workable discovery. So what I suggested is that they order the property. It is possible for an investigator on Tuesday to have gone and picked up some of this evidence to bring it over to the DA's office. I don't understand why this cannot be done until the 14th. But investigator goes, checks out the evidence, brings it to the DA's office. The DA's office then takes the round disc that's marked exactly the way that EPPD marked it. We get a copy of it. It's marked exactly the same way. It's listed in a hand delivery slip, a pretty clean hand delivery slip. This is the name of the video surveillance that was turned over, for example, in this case, and then we sign for it. And then whether it's smack in the middle of this murder trial when we're disputing whether or not we got discovery, or for a writ 15, 20 years down the road, it is crystal clear that the discovery on a magnitude of a murder case was turned over. So I guess I'm just trying to put all this on the record. As of today, we still don't have a copy of our client's statement. As of today, none of that electronic discovery has been turned over in a workable fashion. I know that they started working on it. I know they did the evidence review. I know Mr. Herrera has very professionally reached out to me saying, this is what we're trying to do right now. I just want the record to reflect that they are late, very, very late. They have had notice that this was set for trial. But for us doing our work on our end, this still may not have been discovered that no evidence review had taken place on a February murder case until the eve of trial. I guess in our motion, Judge, we are trying to get ready for trial, and we need discovery. I know that I put in our motion that there has to be some sort of relief that for what is happening here and what has happened. I know that the relief I believe that we're asking for right now is that we go to trial. We are in a position, and I know every murder case is different and every defense attorney handles it differently. We're in a case where we truly believe that from the get-go, our client is stating a bona fide self-defense. That would be 100%, that there was a bond hearing where the state of Texas argued our client was not allowed to use deadly force with the knife because he had taken the knife out of the victim's hand and had disarmed him. That was the response to our argument of self-defense. We are ready to go to trial. We want to go to trial. I don't know how, I just don't understand the extent of how this kind of case does not get worked up. Our client is sitting in jail. Our relief, Judge, is, and this is what we've been asking, is no continuances granted. And if for whatever reason that is not our relief, we're asking that at least our client not be held in the county jail at a delay that is no fault of his own.
Okay, Mr. Herrera, I hope you were taking notes because Ms. Butterworth basically is providing your office with a lesson on how to handle a murder case pretrial. You know, Mr. Herrera, and I in a certain way feel somewhat sympathetic for you because you are probably my 6th prosecutor this year, and you're my frontline prosecutor now. And I know that you have been doing your best to work through things. But the reality is, you know very well, because you're on other cases that have come up recently now that we're looking at trial, where, you know, they're both murders. There are actually 3 cases, 3 murders, where it is becoming apparent through these defense requests to review and inspect evidence that the DA's office has never looked at the evidence in these cases, has never touched the cases. And I know you haven't been the prosecutor on these. I hear references to proverbial passing of batons. For my purposes, that's not going to cut it. We have a trial. So let's go back. Ms. Butterworth is absolutely correct. The court's patience and understanding with situations like these, which to my absolute frustration, I'm afraid might be common, and that is very scary for the court to stomach at this point. We are set for jury trial on December 2nd. That is when we have jury selection, and let me just make sure, because we have so much going on with respect to jury panels. I just want to make sure I don't misspeak. And then we'll get back to all of those very important substantive details, but let me just go back to the schedule so we're starting off on the right track. Yes, December 2nd, we have 2 panels that day. Two panels would mean 114 jurors. In reviewing the master calendar, let me make sure, I do not have December 3rd. And so that means we have a total of 2 panels for December 2nd. I just want to review the panels. The remaining panels I have in December are for another case. So I have 3 additional panels. Okay. So with that said, let me go back to the case. The relief that you're requesting, let me ask, because I think I'm also learning about the process. Mr. Herrera, I'm only basing this on something that I heard in another case from your office. Is there not a list, a list that identifies the, I guess, 102 pieces of evidence that clearly identifies, not by some number or anything, that is not that is available to defense counsel?
Yes, Your Honor, that is up on portal. Okay, that list is viewable on portal. And it's the same list that we have access to, that the state has access to. And just to address a few of the things that Ms. Butterworth was alluding to, I will request those. I have requested those items and will provide a copy labeled exactly as she is requesting, so that there is no question as to what was delivered and the description of each item. And that the list of those items, or excuse me, the description of those items is how they were listed on portal. I know when certain videos do get uploaded, some of those do, it's a list of numbers identifying those. But I mean, if you go back to the list, you can see and match the items, right? But I'm willing to go the extra mile and give those discs with
Mr.
the
Herrera,
description.
please don't say go the extra mile, because quite honestly, your office has done anything but that up until this point.
Well, and Your Honor, I'm just describing as to what is being done as of now. I mean, what
Understood.
the court's concern and the defense's is not lost on me, but I'm doing what I can now to do that. And the defendant's statement is up on portal now. And Ms. Butterworth, Mr. Carmona, it's listed as interview, okay, MP, and it's an MP4 file that was uploaded yesterday. Now I will get a copy of that, upload it onto a disk, and provide those, hand deliver that as well. Now, Judge, as far as the stuff that we're getting on the 14th, I can get an investigator to go pick it up and have it available before that.
Have you all discussed scheduling a physical inspection for defense counsel?
Yes, Judge, and I need a, obviously, there's two offices, so Ms. Butterworth and Mr. Carmona's schedules, calendars might not always align, but as soon as we can narrow it down a couple of dates, I will send that over to the PD's office and get that scheduled with them.
And I had told, yes, Judge, and I had told Mr. Edda, he did email yesterday wanting to set up the evidence review, but again, I reiterate, I need the discovery first before we can go look at this evidence.
So when you say to the discovery, Ms. Butterworth, what are you referring to?
Well, for example, so in the motion, or in my motion, there are things that have not been turned over for us to be able to continue to prepare. For example, and this is a better probably argument, in this list of evidence that was created, that is on portal, there is something that's just called, for example, it's designated. This is literally how it's designated: a copy of the scan disk thumb drive.
Okay.
I need to have an educated evidence review, which means we need to look at all of the discovery first before we go over to the property office to start looking at the tangible pieces of evidence. I listed in the motion, obviously, first and foremost was our client statement that as of Tuesday, we did not have. There is another DVD interview of a witness that we're asking for. I need to watch that. We need to watch that before we go to the evidence review. We're asking for the victim's Facebook records. These are things that are just, they have not been turned over. They're alluded to in the discovery that's been provided so far, only as a name of it. We still need the actual substance, and in order for us not to waste anyone's time, we need to finish looking at that before we then go look at the rest of the physical evidence.
So in terms of items that are documents, things that are files on drives, is that what you're saying? All of that is going to be turned over, I guess, what did you say, by tomorrow, or when did you say, Mr. Dada?
Well, by the 14th, but I'll get it sooner, Your Honor.
Yeah, no. So if it's something that is clearly, if it's some type of data file, anything that is easily transferable like that, I can't see why it would take any longer literally than 24 hours, especially if you've already been looking at this case. So your deadline to turn over all of that is going to be tomorrow at 3 p.m. What also needs to be produced to the defendant by tomorrow at 3 p.m. is a workable, I need that list, whatever is being turned over to defense counsel that is identifying these 100+ pieces of evidence, needs to say what they are. So if there is a video, it needs to be identified what it is. That for each piece of evidence, Mr. Herrera. So I don't know if you need to get other folks on that, but it needs to be turned over by 3 o'clock tomorrow.
Yes, Your Honor.
From there, I think we need a very quick turnaround. I don't know, as much as the defense's argument is, I don't know. Tell me a little bit, if you can, Ms. Butterworth, Mr. Carmona. Let's just say, and I'm trying to think this through, in best case scenario that we make significant headway in terms of disclosures, inspection of evidence, things of that nature. I mean, do we have enough time to be ready for trial?
We are ready today. And this is new to me. We're ready today because I have the luxury of not having the burden of proof.
Right.
We're ready. We are ready today.
Okay. So we're going to go with that disclosure by this Friday, 3 p.m. So that's tomorrow. Let me look at my calendar. So as I was asking about potential dates for inspection, had you all looked at any potential dates?
I had not heard back, Judge, and obviously that's because they want to look at these other items first. So I'll provide those by the court's deadline. And in the meantime, I mean, I don't know how long it would take to review that so that we can have that actual evidence review at the property office.
And obviously, I can only assume, Mr. Odetta, the evidence review will be minus the items that are still about to be sent to DPS for testing, correct?
Correct. Now, those are, and I can tell you right now, I mean, it's limited to buckle swabs. So those are things that obviously are listed in the evidence list. So I mean, you can identify them based on the list. I don't know that actually holding them and seeing them will
That would be fine.
do much good. But yeah, most of the
Right.
items are swabs, and there are clothing items that are being sent to the trace office, okay, so that they can have DNA traced and then forwarded to the DNA office. So there are other items and additional that don't count towards the 10 that are being sent to trace.
And if you make a request in writing to DPS on a murder case, they will allow you to send more than 10 items. The request has to be in writing.
Yep, I've done that request, Judge. So if they're allowing me to send more than 10, we will certainly do so. But I've made that request in writing.
Mr. Odetta, did you ask DPS or have you contacted DPS on their turnaround time or what they think it might be?
For this many items, what I understand, Judge and Ms. Butterworth, it's about 6 months. So anywhere from 120 to 180 days.
And so again, Judge, for the record, I would reiterate what we're asking for is no continuances based on an unnecessary delay of even the items haven't even been sent yet.
So I have defense requests noted. What I'm trying to get through is some initial steps because we have a trial on December 2nd. So how quickly can you all review what he turns over in, digital form? I guess my goal is to have something, an inspection completed by the 15th of October.
An inspection of the physical evidence at the property office?
Yes, ma'am.
If the deadline for us to receive these items, let me look at my list again, by 3 o'clock tomorrow.
I don't have a problem going to the 18th. I'm actually just trying to get this done quickly.
If you'll give us till the 18th, Judge, I assume that would be enough time for us to go through what's being turned over and for us to schedule the evidence review. We'll probably schedule it out of an abundance of caution on the 18th, give us 2 weekends to work on this.
Mm-hmm.
I just want to make sure too that some of the things I was asking for was also the forensic reports of whatever was downloaded by his name. He's Officer Lucas Cervantes. I just want to make sure that's also what we're receiving because some of these electronic items were, I guess, attached to some sort of software so that the contents of, for example, the victim's cell phone were dumped, and then there's a report generated that allows us to look at calls, photos, text messages. I will tell you, Judge, that kind of stuff is voluminous to go through. And so are Facebook records. But and then I don't even know what's on scan disk thumb drive. That's all it's being identified. But I think we'll just out of an abundance of caution, let's say we'll schedule the evidence review on the 18th. And that gives us 2 weekends to go through the discovery that we should be receiving by tomorrow at 3.
Let me clarify with Mr. Odetta. Mr. Odetta, I know you have the motion and you've been discussing with defense counsel. on that portion of the motion where it's the DVD, thumb drive, it's identifying a phone, an external hard drive, things of that nature. When we're talking about the digital evidence or things that can be transferred, produced to defense counsel on a disk or however you do it, is this included in that? Or are you just talking about other reports? And then of course the forensic reports.
No, that's what I'm referencing, Judge. And some of those items, like I said, we already do have. I think we've got the iPhone dump, and then if I'm not mistaken, the phone, the T-Mobile number dump as well.
So for every item that is basically going to be produced to defense counsel in that manner, to the extent that something is not produced, I'm going to need the state to identify why it's not produced. Okay.
Yes, Your Honor.
And so I don't know if you want to do some type of inventory that gets filed with the court in response, something of that nature. I just want to know specifics. I don't want to come back later and find out all kinds of different reasons.
Yes, Judge.
Just keep it all together. Okay. So then I'll leave it on you all to see what you can accommodate in terms of that inspection, and we'll be back on the 19th, October 19th at 10 a.m. Well, let me ask Mr. Carmona, Ms. Butterworth, we haven't done these at the jail slot. Do you want to do them at the jail slot, or are you okay doing them in the morning?
We can do them in the morning, Ms. Butterworth. We're open.
Okay. I mean, anticipate this is going to be an ongoing check-in. Ultimately, I'm holding off for now, Ms. Butterworth and Mr. Carmona, on the ultimate relief that you may be requesting. I'll tell you for the state's benefit and for yours as well. I'm less inclined, I think what you were asking for, okay, you're asking to inspect evidence, grant the motion. I'm less inclined to pursue relief on the bond, although I'm going to keep that option open, as I am more inclined to look at potential exclusion of evidence. And so I'm just letting you know, we've had plenty of time on this one. I think this trial was set back at least in June. Defendant has been in custody since February, was indicted in March. So again, we'll see you on the 19th. If there's anything that comes up in the interim, I urge you to file any kind of pleading that you need to and notify us immediately if we run into any problems. Ms. Perez, I know you're working on this, so just keep working on it, and we'll see where we are on the 19th.
Yes, Your
Thank
Honor.
you, Judge.
Thank
May we
you.
be excused?
Yes, sir. Thank you all for your hard work.
Judge,
Thank you.
Mr. Carmona had one other matter that was reset from Tuesday.
Okay, yes. Was that Ms. Velasquez?
Yes, Your
Judge.
Honor.
Mm-hmm. Okay, go ahead.
Cause number 2020-020-2042, State of Texas versus Virginia Velasquez. Announcement of counsel, please.
Brian Herrera for the state of Texas, ready, Your Honor.
Omar Carmona for Ms. Velasquez, ready, Your Honor.
Okay, and we pushed back this final hearing plea deadline. What were we waiting on? Must have been waiting on something.
Yes, Judge, there's a P file case that has yet to be indicted. So I've requested that be expedited so that we can move the present case along. It's a Socorro PD case, Your Honor. So I went ahead and sent the request so that we can that can go before the grand jury immediately.
Mr. Herrera, what is it? I'm sorry, I don't remember.
It's a possession, Your Honor. Let me.
Possession, is it the 4 to 200? Is that what I'm seeing here?
Yes, Judge.
Okay, that's showing an offense date of 2020. Wow. Is that right? Do I have the right one? Am I looking at the right one?
That's correct, Your Honor.
Yes, Your Honor.
And it's May 2020. So we're almost a year and a half out. Okay, is the warrant, let's see.
And all we would be urging is, and we're amenable. If Mr. Herrera, Socorro's taking their sweet. Mr.
Are we
Herrera's,
losing Omar, or is it
Socorro
me?
has.
We lost you for a second there.
Yeah, we lost you.
Oh, I'm sorry. you know, I know this has been even since before, way before Mr. Herrera's time, that Socorro historically has taken sweet time to get cases up. Mr. Herrera, if you're willing to make us an offer on the case that we have at bar, you know, maybe we can, you know, cut that possession case loose. And if not, if you still want to take it, I understand that too. But then, Your Honor, we would urge our motion to recall the warrant.
So we have her for the same thing. So that's what it is. Okay. I don't know. I mean, technically we're set for trial on the 8th. In terms of the motion to recall, thank you, Mr. Carmona, but that will not be granted.
Yes,
if I can put it that way.
I can try.
I didn't want to say denied. It's the same thing. Anyways, look, I don't want to put you all too far out. Is that something you're going to look at, Mr. Odetta, or you're just going to go push on Socorro?
Absolutely. No. I mean, I've made the request, but we'd probably be waiting for labs anyway. So yeah, I think that's reasonable, and I'll take a look at
we're gonna move the final hearing plea deadline to October. That week of the 18, 19, 20 is going to be busy. October 25th at 10 a.m. If you all have some agreement, send it on over. Great. If not, maybe Socorro will listen to you, Mr. Odetta, and you'll have a different update.
Judge,
Monday.
I'm so sorry. Mr. Filemon Sanchez is co-defendant in this matter. I don't know if Mr. Carmona has had an opportunity to talk to Mr. DeCotes. He was a no-show Tuesday.
Is he here?
No, ma'am. And he's supposedly in trial in CCR4, but I have not yet been able to confirm, ma'am. I just didn't know if you want me to reset for then as well or address separately.
Well, I kind of want to know, let me see, what's today? Let me go to the calendar now that I have this nifty calendar. What's today? October 7th. He's in trial in CC4. Is that what it was? I'm sorry, Sandy, who was it?
I'm sorry, Judge.
He's in trial where?
CCR4 is what his office told me, ma'am.
Okay, might be. Let's go ahead. Yeah, we'll put him on the same date.
Thank you, ma'am.
Yeah, it looks like they picked a jury yesterday. Okay. All right.
Thank you, Judge. May I be excused?
Yes, sir. Thank you very much.
Bye-bye.
Who's next, Chewy?
Judge Silva, page 6.
Judge, if I may, on this one, and good morning, Judge Munoz. This is a funky one, for lack of better words, where we're working with probation to get a corrected form to us, I believe. Oh, there you are. Sorry, my little box has moved. To get a proper discharge submitted to the court, Judge.
Is this the one we just emailed about?
Yes, ma'am.
From the 346?
Yes, ma'am.
Okay.
Okay, if I may, Your Honor,
Yes, sir.
for the first week and a half, I couldn't find Miss Silva because I went to the annex, she wasn't there. And then I went downtown, they finally found her. And she was booked under the last name of Nieves.
And she's booked on this case?
Yes, but under, she on the new arrest, she's booked under Nieves. I don't know what the new arrest is, but definitely she's booked on this case on a rebel. But I went to interview her when I found her, and she said that she already had an attorney, but she couldn't remember the name of the attorney. The only name she knew was Alec, A-L-E-C. So
It's not Alec Shawala? Okay, so wait a minute. This has got me a little bit concerned because the only thing we're set for a probation status hearing, Judge, and the only thing I saw is that we had a transfer in September, so less than a month ago, just a few weeks ago, from the 346th. I get an email, let me see, conflict. Okay, this is strange because, am I understanding correctly, Ms. Pineda? Miss Silva was done with probation, and this is without any kind of rebel, right?
Yes, Your Honor. So
since 2020.
Yes, she's under Valerie Silva, and yes, she's also under Valerie Nieves. However, the 2016 case, which was the probation case that was originally out of the 346, that case expired back on 10/3/20. So a year ago, that case expired. We're pending a discharge. And that's what we're pending right now, just to make sure to get the correct order in, just to close it out as it was a deferred case.
Mhm.
But there was no motion to adjudicate filed prior to the expiration date or anything like that.
So there's no, wait a minute. So hold on, let me stop you right there. So there's no reason that she should be, if she's in jail right now, she's not being held on the probation case, right?
And Judge, if I may,
Sure.
so she's being held on a new possession case.
Mhm.
Offense date September 10th, 2021, and Alex Shawala is the attorney of record on that one.
Okay, but she's not being held on the probation case, the 2016 case.
And I don't think we ever filed a motion to adjudicate or motion to revoke. So it's completely on the new case, on the new charge.
Okay, Judge, that's what I wanted to make clear, because it looks like the 346 should have dismissed, taken her off since 2020. And yet somehow the fact that she completed probation got missed, and somehow it gets transferred. What was the probation? It's assault. Oh, okay. That's why they probably saw the offense date, and the offense, and that's why they said conflict.
That's what it was, Judge.
She's no longer in custody, released on a $10,000 surety. Okay, so she's not in custody anymore, but in any event, Judge, she was only being held on the new case, and you're not on that case. I'm just inquiring, when I got the email this morning, Judge, I'm just inquiring as to the procedure, but now that I see the case study, for my purposes, let's just take care of the discharge.
Yes, ma'am.
Yeah.
I was already working on the discharge, and that'll close it out on our end.
I was concerned, Judge, because there was an indication from probation that the discharge orders had been provided to the court in 2020 and again in September 2021. However, we did not receive those. So I'm thinking maybe probation was confused. Well, not confused. They were sending them to the 346, and that they were in the process of transferring her to us.
Well,
So if I got it just so I can sign a discharge, so be it. It'll be signed.
thank you, Your Honor, and I guess I'm off the case now, and it is a funky case. It took me forever to find this lady.
You did great, Judge.
I'm sure.
Thank you, my excuse.
Yes. Or are you appointed, Judge? Yeah, you're appointed.
Yes, I'm appointed, yes.
Send your voucher, please.
Thank you.
Okay.
Y'all have a good dia, okay?
Stay well. Who's next, Chewy?
Hey, Judge, the Martels,
Okay.
cause number 2021-0D00640, State of Texas versus Randy Martel, cause number 2021-0D00641, State of Texas versus Christopher Martel. Announcement of counsel, please.
Brian Herrera, on behalf of the state, ready, Your Honor.
Good morning, Your Honor. Joe Spencer on behalf of Christopher Martel, and standing in for Felix Valenzuela on behalf of Randy Martel.
Okay, so we were using this just as an update, I guess, from our hearing on Tuesday. What have you all worked out, gentlemen?
Your Honor, we have a evidence review on next Tuesday at 12:30. Ms. Hill and I have already worked that out, so that's in the process. The other thing that came up on Tuesday, Your Honor, is there was some confusion about the audios, a message that I got. I was able to find the message. I gave it to Ms. Hill yesterday, and it actually came from Mr. Herrera, where he's indicating there's 2 audios available for viewing. So I was able to show her that as well.
And those were the ones that I think Mr. Herrera had mentioned also, no? At the same,
Yes.
so there's no additional.
No, Judge. We've got those. I think it's like 20 minutes worth of audios. They're available for listening. I know there's a protective order out, Judge. So, I mean, I don't know. I think I might need permission to make a copy of those. I from what I understand.
Is that what you're requesting, Mr. Spencer, is a copy?
Correct, Your Honor. Right.
Okay.
Absolutely.
Okay, and so that's going to be granted, Mr. Herrera. I'm not sure on the protective order if you need to provide some type of documentation to the court so that you have something written. and filed in the court
Yeah,
record.
it's a forensic audio, 20 minutes, about 20 minutes of forensic audio, Judge.
Alrighty, what else do we have left? So we're gonna do the evidence review on the 12th. Let me go back to this case. I feel like we should set this on the 19th at the 3 p.m. Jail slot for an update. Let me go back though. Let me pull this case up. Mr. Spencer, and I know you're covering for Mr. Valenzuela. I mean, is it fair to say we can remove this December trial date? Or yes?
Yeah,
We've
Yes, Your Honor.
said that many times, but I think we're on top of the issues, at least in terms of the evidence that were most pertinent, but I know that December date is not realistic. So I am going to leave the final judges conference on November 4th, adding that October 19th date at 3 p.m. And then we're going all the way to March of 2022. I feel very comfortable that I'm going to hear from you all outside of those dates. And so we're still left, I think, for my purposes, Mr. Spencer, with the motion to review evidence and the relief you've requested therein. We will address if it's the same relief you're requesting in the motion or anything in addition to that on the 19th.
Your Honor, yeah, we'll just wait till after the evidence review, and if we feel we have to re-urge any motions, we will certainly come to the court. Judge, you made a comment, and just because I'm checking my schedule, that we'll go to the backup date of March. I have our backup date of April 8th. That's what I have. Am I?
Okay, no, it's April 8th. You're right.
Okay.
I have a final
Okay,
judges conference on March 8th, and then final hearing plea deadline trial on April 8th.
Okay. Yeah, I just wanted to make sure. Thank you.
Let me ask you all right now, because I'm just going to go off of the protocol we have today. Assuming everything's the same, how many jurors are you requesting in terms of how many panels? And I'm going to go based on the max we can get in Commissioner's Court is 57. You all need 3 panels, or do you want 4?
I think we can do it with 3, Your Honor. I don't think we need 4 panels. 2 would be very tricky. Just kind of depends on the issues, but 3, I think, would get it done.
Mr. Herrera?
Judge, I think 3 would be sufficient. Hopefully by March, this won't be an issue. But for now, I think that would be okay.
So the only thing I don't want to have happen again is what we found here in October, November, December, which is basically a crazy rush to reserve panels. And then I'm trying to pick dates all over the place around everybody else. But we need to put in, so let me tell you what that means for me though, is if we're going to do 3 panels, I'm going to request, it's actually going to be that we start on the 7th, okay? So it'll be 2 panels, 1 in the morning, 1 in the afternoon on the 7th. And then we'll do 1 panel. Shoot, I might request the 2 panels for the 8th as well, just in case.
And this is May or?
This is April. We're set for trial April 8th. So that's the Friday. That's kind of how we schedule it. But practically speaking, because we're going to need so many panels, we're starting on the 7th. So just know that. Chewy, is Chewy here? Yes, okay, because I feel like I'd be a host. Okay, so we need to get those requests submitted today so nobody beats us. It might not mean anything. They might think we're crazy for asking for them, but that's okay. Let's get them and hopefully we'll get them. So, all right, with that said, then we'll see you on the 19th, gentlemen. Thank you very much.
Thank you. Maybe excuse Your Honor.
Yes, sir. Thank you.
Thank you.
Who's next, Chewy?
Okay, Judge Paul Duchesne.
Okay. This goes here.
Judge, can you check your chat?
It's because I'm here. Am I a co-host? Because now I'm hearing things that I don't usually hear.
Yes, and then
It's
I just
telling
wanted
me-
you to,
Uh-huh.
I wanted you to see who was in the rating room, that's all.
Okay, okay, so is everybody in here? That wants to be in here?
Well,
Oh, okay.